Hello and welcome back to Mourant's Vlog Series. Today I'll be talking about the drafting of trusts and why it's different from other types of document drafting. I know that doesn't sound like the most exciting topic for a vlog. Let's face it, most people don't think that the drafting of documents is interesting, but hang in there and I'll try to explain. First of all, why does trust drafting matter? It matters because trusts are concerned with the ownership of assets, in some cases very valuable ones. Quite frequently, their function is to hold family wealth over more than one generation, and so can last for a very long time. If the drafting is not done correctly, then it can be very hard, even impossible, to fix it. Sometimes the only way out is to apply to the court at some expense, and as with any court proceedings, the results can be unpredictable and might not be what the person who created the trust would have wanted. Sometimes the result may be that the trust is invalid, which can lead to other problems such as arguments over who is then entitled to the assets. So, hopefully, we can all agree that it's important to get the wording of the trust right. But why is it different from any other document drafting? A little while ago, a lawyer from continental Europe, where the trust concept is less well understood, asked me what the differences were between drafting a contract or agreement on the one hand and a trust on the other, which got me thinking about this as a topic for this vlog. It took a little while for me to figure out the answer, but it's this. When you draw up a contract, there is not much that the law prevents the parties to the contract from including. Granted, there are some limits. For example, you can't agree to do something illegal, but in the main, these are exceptional things that most people wouldn't want to include in their contract anyway. Contrast that to drafting a trust. There are lots of things that you might consider saying in a trust which might sound totally uncontroversial, but which have legal consequences that might come as a surprise to a non-trust lawyer. Some of that comes from the fact that trusts create rights enforceable by other people, such as beneficiaries, whereas traditionally contracts are a matter only as between the parties to them. There's also a whole body of trust law developed over the years that effectively limits what a trust instrument can or should contain. It's a bit like navigating a boat around a lake with submerged rocks and sandbanks. If you know where the hazards in the lake are, as hopefully your trust lawyer does, then you can avoid them. To push the analogy to its extremes, hitting a rock may be catastrophic, e.g. in the case of trust invalidity, and so is definitely to be avoided. Whereas bumping up against a sandbank may just give rise to inconvenience, such as extra expense. To illustrate, let me give you some examples of things that can go wrong in the drafting of a trust. An example of a serious problem would be one where the trust instrument doesn't actually create a trust. That can happen in a number of ways. One of those would be where the trust is too vague, such as where the language used is not certain enough. The law requires some elements of a trust, such as the description of the beneficiaries and their interests, to be described with certainty. Another would be where the trust purports to make someone the sole and absolute owner of the assets during their lifetime, with power to dispose of them as they like. Under trust law, that doesn't confer any rights in the hands of other beneficiaries, and so would not create a valid substantive trust. Other pitfalls are less serious in that they do not invalidate the trust as a whole, but nonetheless should be avoided. A common desire on the part of those who create trusts is to try to predetermine a long way into the future what is to happen to the assets, for example in the case of a family business. Whilst that desire is completely understandable, it's always a good idea to build in some flexibility to enable the arrangement to be varied to address changing circumstances. Unlike a contract, a trust cannot be varied by the parties to it unless that is specifically provided for in the trust instrument. These are just a very few examples of the problems that can arise where a trust is drafted without a full awareness of the underlying trust law principles. There are many more examples that I could give, but we just don't have time for that today. My top tip: time and resources spent ensuring that your trust is properly drafted by lawyers with trust law experience is never wasted. I hope you've enjoyed this short vlog. Please watch out for further episodes in the Mourant Vlog series.